Morning, everyone. Welcome to Watershed's latest webinar on IR35 and the recent Supreme Court judgment on Uber. So if you've joined thinking this was your morning yoga session, then you might want to sign off now. I'm not planning on doing any sort of yoga moves, but what we are planning on doing is talking a little bit about IR35 and the Uber judgment. This is a live webinar again, and you've got me, Jo Hale, and my colleague Ian McGlashan, who's going to join us shortly to talk about the Uber case. We think it's going to take about 30 minutes. And like I say, it is a live webinar. So if you've got any questions, then do pop them into the live event question and answer box that you can see on Teams. If we don't get round to answering everybody's questions, then we will pick those up after today's webinar. So do bob your email address on those questions so that we can make sure that we can get back with any replies. One of the other things I ought to say is we at Watershed are not tax advisors. We're not tax specialists. We are simply advising on the or giving a presentation on the off-payroll working regime and the Uber case insofar as it amounts to determining the status of a worker that you use. If you want any tax advice, then obviously you need to go elsewhere. But let's just tell you a little bit about the contents of the course today, or the webinar today. We sent you these little teaser questions to try and entice you to join our webinar. And hopefully these are the things that Ian and I are going to try and answer. I'm going to start off with the off-payroll working rules, looking at what type of engagement the new rules will apply to, talking about whether or not you have to complete a status determination statement and who you've got to give those to, and what the consequences are of maybe getting that wrong. And then Ian's going to talk a little bit more about the Supreme Court case, Uber versus Aslam and others. So right into it then, everybody. And next slide is a bit of a brief summary about the off-payroll working rules. We know it's effective from the 6th of April 2021. I know there was a lot of businesses out there that were hoping it was going to be delayed for another year. It was delayed for 1 year, but it is going ahead from the 6th of April. So that means it's applicable for any assignment that is going to hit that 6th of April 2021 date. So if they've started now, but they're going to cross over the 6th of April, then it'll apply, or if they start on the 6th of April or any time thereafter. The off-payroll working rules apply in circumstances where you engage a worker to provide their services personally through an intermediary, often their own limited company. That intermediary they must have some material interest in. So they provide their work through an intermediary to you. They can sometimes also provide that service through another. So there'll be a contractual chain, but the principal impact or effect is that that worker is providing services directly to the client, personal services to the client. If an engagement is caught by the off-payroll working rules, then effectively what happens from the 6th of April is the burden of determining the status of that worker shifts to that end client. And it's the end client that has to determine the status of that worker, rather than the current regime, which is that the intermediary determines the status of that worker. So there's a shifting burden of responsibility. And what you have to decide is whether or not that worker is a self-employed contractor or a deemed employee under the off-payroll working rules. One of the other things I ought to mention is us employment lawyers have analysed status and come up with 3 different types. Self-employed contractor at one end, an employee at the other end, and a worker in the middle. And Ian's going to come on and talk about the definition of worker. But for the off-payroll working rules, the HMRC only have two types. They only have two statuses. You're either a self-employed contractor or you're an employee or a deemed employee. So we've got to remember that in relation to this off-payroll working regime. And essentially what the off-payroll working regime is doing is not only shifting the burden of determining the status of that worker, but it is also making the fee payer responsible for the tax and national insurance deductions and the tax and national insurance payments to the HMRC. So now moving on to the next slide, we're going to look in a little bit more detail about the contractual chain. And this is essentially what I was talking about earlier. That line between XY Limited all the way through the fee payer, intermediary and worker is what I'm going to refer to as the contractual chain. So none of that is going to have changed. You still might be contracting with a fee payer to provide a worker through an intermediary. And there are various contractual relationships through that horizontal line. But the primary thing here is that that end worker is providing services personally to XY Limited, albeit through a contractual arrangement of an intermediary, but effectively providing their services personally. And that's the type of engagement that is caught by the off-payroll working rules from the 6th of April 2021. Now you'll see in blue under XY Limited, I've said if it's a medium or large company. And under the intermediary box, I've put points to note: sole trader, an agency, and fully outsourced. Now, those elements are important because they determine elements of engagements which are exempt. So where these off-payroll working rules do not apply. And if we look onto the next slide, I go into those in a little bit more detail. So the off-payroll working regime from the 6th of April 2021 will not apply where the client is a small organisation. And the definition of a small organisation is found in the Companies Act. And a small organisation must satisfy two of those bullet points below. So an annual turnover of not more than 10.2 million, a balance sheet total of not more than 5.1 million, and not more than 50 employees. If the client organisation satisfies two or more of those elements, there'll be a small organisation and the off-payroll working rules do not apply. The burden of doing a status determination does not shift. The burden of collecting tax and national insurance does not shift if you're a small organisation. The new off-payroll working regime also does not apply where workers are providing their services as a sole trader. If you recall, when you looked at the contractual chain before, the worker had to provide their services through an intermediary with which they had a material interest, which is usually what is known as a personal services company or a private limited company set up by the worker in order to provide their services. Where they're providing their services as a true sole trader, these off-payroll working rules will not apply. Of course, that sole trader still needs to make sure that for HMRC purposes, they satisfy the definition of a sole trader and a self-employed contractor, but these new off-payroll working rules do not apply. They also do not apply where you are contracting to provide with another to provide a fully outsourced services. In such circumstances, the service provider is deemed to be the client. And according to the HMRC, whether something is fully outsourced will be a question of fact. They'll take into account things such as the nature of the business, the nature of the service provider's contracts, and the relationship between the service provider, the worker, and the customer. There are examples given in the HMRC Employment Status Manual, but some examples might be a fully contracted out cleaning service or something like that, where the status of the worker and the requirement to make sure that all of the tax and national insurance regimes are complied with, they remain with the service provider rather than the client. The other exemption is where the agency rules apply. And in this instance, it's where the worker is contracted through an agency, and that agency already has the worker on their payroll. So they're already deducting PAYE from that worker. And in those instances, the burden does not then shift up the contractual chain to the client. The agency remains responsible for collecting the tax and national insurance and determining the status of the worker, etc. One of the important things to note is that the HMRC don't like blanket responses to issues. So when you're looking at whether or not an engagement is caught by the new off-payroll working rules, take into account these exemptions. So now let's look at the status determination statement. So we've satisfied ourselves that the engagement is one where the worker is providing personal services to us as the end client or through another fee payer via their intermediary with whom they have a material interest, and we've decided that that engagement is caught by the 6th of April 2021 off-payroll working rules. Those off-payroll working rules then mean that there's a burden on us to determine that worker's status. And so we have to undertake an analysis of the true underlying circumstances of that service provision and whether the worker is considered to be a self-employed contractor or a deemed employee. So what do you consider when you're looking at a status determination? It's exactly the same as all the considerations that we've thought about previously, all the considerations that were established in a ready mixed concrete case, in fact, in 1968. And I've set out there some of the primary things that are given consideration. And if you remember, if you've ever had a conversation with any of us in the past, it's a balancing act. There will be some aspects of that relationship which tend to suggest that the worker is an employee. And there will be some aspects of that relationship which tend to suggest the worker is a self-employed contractor. And what we have to do is take those sort of defining features and determine on balance whether or not they are a deemed employee or they're a self-employed contractor. So the primary things that you need to look at are things like mutuality of obligation. Will there be, for an example, an obligation on you as the client to provide that worker with more assignments and more projects and more work after this current assignment is finished, for example? Is there an obligation on you to do that? Is there an obligation on the worker to actually do that work if you ask them to? If you remember, the bedrock of an employment relationship is that an employer must provide work to an employee, and the employee must do that work. That's where the mutuality of obligation exists in an employment relationship. But if in fact this is a one-off project or assignment which you're asking the worker to do, and there isn't any obligation on you to provide them with further work, and indeed the worker doesn't have to accept any future work, then that mutuality of obligation won't exist. Substitution, you'll have heard about this a lot. Can the worker who is currently providing personal services to you provide a substitute in circumstances where they can't carry out the work? This is a classic test. There's nothing abhorrent in a self-employed contracting relationship for the worker to provide a substitute that is suitably vetted and suitably qualified. So if you as the end client say, yes, I'm prepared to accept a substitute, but they must still be reference checked and DBS checked, and they must still have the correct certification to carry out the work, that's okay. That doesn't defeat substitution. If the client maybe has to put them through a rigorous interview, assess them from a quality perspective, do more of a detailed analysis about their suitability, then that might not be true substitution. And if there is a right to substitute, it doesn't matter whether that right has been exercised or not. If it exists and it's truly accepted that it is a possibility to provide a substitute, then it doesn't matter that it hasn't been done previously. Substitution can still exist, and obviously what we know is that tends to suggest that the person is a self-employed contractor rather than an employee. Supervision and control. This is another classic tool and test. Who is in control of the work that the worker does? Is the worker a professional in their own right that is responsible for ensuring that they undertake the work with due skill and care, that they're responsible for rectifying any mistakes at their own cost? Can they do their work as they see fit, albeit that they might have to comply with some internal policies and procedures, or perhaps be available in working hours and those sorts of things? But, generally, are they responsible for making sure that they do the work in accordance with the project or assignment that has been given to them? They're going to have to feed back to the client, of course they are, but who supervises them? Do they have any direct line management interaction with somebody in the client, or do they effectively supervise their own work and just feed back results to the client? So that's the sort of supervision and control element. And obviously then we go under part and parcel. Are they part and parcel of your establishment, if you like? Do they appear on organizational structure charts? Do they have an email address? Do they get invited to social occasions? Do they join team meetings? Do they have an appraisal? Are they responsible and for all of the policies and procedures and regimes that are applicable in your organization? Or are they not part of those team meetings? Do they not have an appraisal? Do they not have any sort of direct line management into the client? There's having an email address and using a piece of your technology like a laptop or anything like that doesn't necessarily defeat self-employed status either, because sometimes clients have to maintain their data securely, and the way that they can do that is by giving people an internal email address and giving people a laptop. It's when you put them on your organizational structure chart, or you start undertaking appraisals and give them access to team meetings and those sorts of things, that it starts to look more like they are part and parcel. Again, if they're given a job title, if their obligations aren't sort of objective specific or project specific, but specific around a job title where they have some line management responsibility for people within your organization, that all of a sudden tends to suggest that they're part and parcel of the organization. As I've said, the HMRC don't like blanket responses, so you need to take each individual arrangement where you think the engagement is caught by the off-payroll working rules and make an assessment of whether or not that person is a self-employed contractor or a deemed employee. And you must look at not only the written word, but the reality of the situation itself. So, what are the options for status determination? Let's have a look at the next slide. If it is determined that the off-payroll working rules apply to the engagement, and the trigger for you to create a status determination statement is met, then you must undertake reasonable care when making decisions about the off-payroll working rules and whether that worker is in fact a self-employed contractor or an employee. There are various different assessment tools. You'll have heard of the HMRC assessment tool that's called CEST. It's got some advantages. It can be done as many times as you want. It's obviously free to use. The HMRC have indicated that they'll stand by the results of a CEST test, but obviously only if the questions are answered appropriately and reasonable care is taken and it's a true reflection of the situation that is occurring. But there are other assessment tools. Watershed have an assessment tool as well that that we would be quite happy for you to access if you need it. And you can get in touch with us after today's session to talk about it in a little bit more detail. But the reason that I like the assessment tool that we use is it's got more detailed questions. It allows all the parties in the contractual chain to contribute to the answers. It enables us to do to interrogate the answers to make sure that we've properly reflected the true contractual and actual position of that worker. And then you get a certificate with the complete rationale about whether it's inside or outside IR35. And that certificate and assessment can then be passed down the chain. You're under an obligation to pass that status determination down the chain to the fee payer and the contractor. And the fee payer, who could indeed be you, by the way, is responsible for ensuring that where they are a deemed employee, that tax and national insurance is deducted at source. So we're then going to move on to what the risks are of getting those status determination statements wrong. Just as normal, the HMRC has powers to investigate compliance with tax. And just as previously, that means that the HMRC can impose fines, penalties, interest, and require you to pay unpaid income tax and national insurance, as it would do in ordinary circumstances when it's assessing tax compliance of your business. But the principal point here is that if you've undertaken reasonable care to do that status determination statement, then you will be free from any liabilities, financial liabilities or otherwise, and that the answers to the questions that you've given actually do reflect the reality of the situation. But on top of that, as I've described in the next slide, there's also potential reputational and business damage if you get the status determination statements wrong. And the reason I've mentioned this is because there's been a lot of hype about off-payroll working rules. They've been in situ in the public sector for 2 years. They're coming into play from the 6th of April 2021 for medium to large organisations where the engagements are covered. But it's not a scary prospect. All it is shifting the burden of responsibility of determining that status to the client. And the assessment of somebody's status is exactly the same as it has always been. So actually, if we do this right and we adopt a proper approach and we analyse assignments correctly, then we're going to increase our reputation and we're going to look good as a business. Businesses need to have a flexible workforce. They need to have resources that come and go. They need to have a static workforce as well. So this off-payroll working regime should not change all of that. It's just another step that we have to take to make sure that we are adopting the correct approach when we're dealing with that flexible workforce. So we'll look at questions at the end, but I'm now going to pass you over to Ian, who's going to talk to you a little bit more about the Uber case. Thank you, Ian.
Good morning, everyone. Hope you're well. So I'm going to be speaking to you about the Uber case and specifically why the Supreme Court decided in favour of the drivers, what it means for your business and what you should do now. And the interesting part about this judgment is that the most significant part of it isn't the decision itself, but the route that the court took to reach it. And I'll revisit that later. Now, Joe's kindly spoken to us about IR35, and that's about employment status. But HMRC and the courts use the same tests. So we need to look at what the courts have decided, what they've determined, why and how, because that's going to inform our own assessment of the status of our service providers. And that then helps us manage the risk of our own arrangements, not just for IR35, but for other employment legislation. It's important to establish the nature of the employment relationship, as that's key to determining the employment rights to which an individual is entitled. So it's key to determining for you as a business, your obligations, your liabilities and your risks, because not everyone who works for you is an employee. Some are self-employed, some are workers, others are supplied by an agency or supplied by another business. And Joe mentioned that employment law, we've got three statuses. We've got self-employment, we've got employees, and we've got workers. For tax purposes, someone's either employed or self-employed. But when we're talking about employees, they are the ones that are entitled to all statutory employment rights. Now, in Uber, which is the case I'm talking about today, the key distinction that we're concerned with is whether someone's considered to be self-employed or a worker. And establishing worker status is a prerequisite for a number of rights, even though they're not employees. And that includes protection from unlawful deductions from wages, entitlement to receive the national minimum wage. And in the Uber case, those were the two claims that the group of drivers brought: unlawful deductions from wages and entitlement to receive the national minimum wage. But establishing worker status, of course, also entitles them to paid annual leave, protection under whistleblowing legislation, protection under the employment discrimination legislation, which can be significant. If they're then new to your business, entitlement to a written statement of terms. And another aspect is whether you as a business are vicariously liable for that person's wrongful acts. So if we look at, still on the first slide, if we look at the definition of worker. So a worker is defined in the Employment Rights Act as an individual who's entered into or works under a contract of employment. But it's the second limb of the definition that I'm going to focus on. Any other contract, whether express or implied, whether oral or in writing, whereby the individual undertakes to do or perform personally any work. And that bit's significant because that's the element that's particularly significant, because Joe mentioned about substitution. Because if someone isn't required to do the work personally, if they've got either a qualified or an unfettered right to send someone else to do the work, then they're not going to be found to be a worker. And still with the definition, or services for another party to the contract whose status is not, by virtue of the contract, that of a client or customer of any profession or business undertaking carried on by the individual. So in English, we're not talking about business to business here. Now, last month, the Supreme Court unanimously upheld the Employment Tribunal decision that a group of 35 Uber drivers were workers for UK employment law purposes. It decided that the private car hire drivers who Uber said were self-employed contractors were workers under that definition in the Employment Rights Act. But they also confirmed that the driver's working time includes any period when they're logged into the Uber app within the territory in which they're licensed to operate and they're ready and willing to accept trips. And that could be significant for other businesses. One thing to remember about this case is that it's a 2016 case. That's when they initially brought their claim, and it went through the tribunal, Employment Appeal Tribunal, and the Court of Appeal before reaching the Supreme Court. So the arrangements that they had then weren't precisely the same that we're familiar with now. And of course, there weren't any significant competitors operating in a similar way, so they couldn't have multiple apps open. If we look at the next slide, and we examine the key reasons why the Supreme Court found in favour of the drivers. And the first one, the drivers' remuneration, what they actually earned, was fixed by Uber, and the drivers weren't permitted to charge more than the fare that was calculated by the Uber app. Uber also fixed a service fee, which it deducted from the amount paid to the drivers. The contractual terms on which the drivers perform their services, again, were dictated by Uber. So there was no negotiation or variation between different drivers. Although the drivers were free to choose when and where to work within the area covered by their license, once they'd logged into the app, their choice about whether to accept requests for rides, again, was constrained by Uber. Uber controlled the information provided to the driver. They also monitored the driver's rate of acceptance, monitored their rate of cancellation of trips, and imposed penalties where the cancellation rate exceeded a certain level. And they did that by logging the driver off the app for a period of time. And this placed the drivers in a position of subordination to Uber. And that word's significant, subordination. And if we go on to the next one, Uber exercised significant control over the way in which drivers delivered their services. And so if we still go back to the previous slide, Uber exercised significant control over the way in which drivers delivered their services. So, for example, it vetted the type of car that could be used. It also owned the technology that was integral to the service, which they used as a means of controlling the drivers. Again, that word control again. By monitoring the rates of acceptance and cancellation, stipulating the routes to be used, and imposing a driver rating system, which they used as an internal tool for managing performance. Uber also restricted communication between passenger and driver to the minimum necessary to perform the trip, and they took active steps to prevent the drivers from establishing any relationship with a passenger capable of extending beyond an individual ride. So, taking all those factors together, it was clear that the service performed by the drivers and offered to the passengers through the Uber app was very tightly controlled and defined by Uber. It was designed to ensure that Uber, not the individual drivers, obtained the benefit of customer loyalty and goodwill. The drivers had limited opportunity to profit from their work through professional or entrepreneurial skill. The only way they could do that would be by working longer hours and complying with Uber's measures of performance. So if we go on to the next slide and think about, well, what does it mean for businesses? Well, the case is going to go back to the Employment Tribunal to calculate compensation for holiday pay and national minimum wage. But there are other implications for what could be a flood of claims. The Supreme Court upheld the tribunal's decision that the driver's working time under the working time regulations wasn't limited to the time spent driving passengers to their destination. So it's not simply when you get into the car. It also included any period when the driver was logged into the Uber app within the territory in which they were licensed to operate, as long as they were ready and willing to accept rides. So that could have implications for people who are considered on call. So if you're in the social care sector, you'll be familiar with the MENCAP case, where the Court of Appeal held that carers on a sleep-in shift in a care home were engaged in time work only while they were awake for the purpose of working. The rest of the time, they're only available for work and not entitled to the national minimum wage. So the Supreme Court heard that last month. We're waiting for the judgment. It's going to be interesting to see whether or not they take into account the reasoning of the Supreme Court in Uber. But I mentioned earlier that one of the significant points of this is the route that the Supreme Court took. And what they said is that in an employment relationship, the normal rules of contract law don't apply. They said an employment relationship isn't the same as a normal contractual arrangement. And that's because an employment relationship is characterized by subordination and dependency on the one hand, and control on the other of working conditions and pay, a hierarchical relationship. So these people, the individuals who are providing the service, need the protection of the law. But what they also said was that any provision in a contract that was trying to contract out of a statutory position could be considered void. Anything in the contract that tried to prevent someone going into an employment tribunal will be void, would be unenforceable. And what they said was the emphasis, whenever you look at any piece of legislation, you've always got to think, well, what's the point of it? What is this law trying to achieve? And they said the emphasis on giving effect to the purpose of employment legislation when assessing the worker status was in spite of any contractual documentation that they might sign. So in other words, if you use a complicated written arrangement to disguise the true nature of a working relationship, it won't work, it will fail. In Uber, they said that worker status was a question of statutory interpretation. We saw the definition of worker on the first slide. It wasn't a question of contractual interpretation. The written documentation between Uber and the drivers wasn't the right starting point. Instead, had to consider the purpose of the legislation, and that was to protect vulnerable individuals who are in a position of subordination and dependence in relation to another person who controls their work. The greater the degree of control, the more likely it was that the individual was a worker. If we go to the next slide, still considering the implications and what it means for businesses. Joe, we mentioned earlier about what the implications were in terms of national minimum wage, paid holiday, statutory rest breaks and discrimination, but also got to think about that workers have protection for whistleblowing. Also, one consideration that hasn't been mentioned much so far is that if someone's a worker, then subject to the other criteria, they may need to be auto-enrolled into a pension scheme. Now, of course, with any judgment, it's fact specific and a different conclusion might be reached in other cases, even people in the gig economy, even taxi drivers on a digital platform. But the significance of this judgment is that it sets a precedent for how tribunals will decide future cases, the route that they'll take when looking at employment status. Now, while the test of worker status depends on weighing up a number of factors, it's clear that the high degree of control exercised by a business that engages individuals will favour an argument that these individuals may be regarded as workers. So, particularly in the gig economy, a likely implication may be that such businesses might have to put their prices up, not only to cover the additional costs required to engage workers in the knowledge that they may have legal rights attached, but simply to manage that level of risk. So we might see businesses amending their platforms to make their workers self-employed. But of course, what we know is the downside is that these businesses, the potential impact is that they may lose control because they want to have a consistent customer experience. They want to have a business that reflects their brand and their reputation. And what you might see instead is a rise in prices to reflect that risk. So if we think about what you should do now, going on to the next slide, of course, you've got to consider whether you should look at your arrangements. You've got to audit your arrangements with all of your contractors, all of your service providers, particularly in light of this judgment because of the route that they've taken. And think about, well, who decides what the work will be? Who decides the way that the work's done? Who decides how it's going to be done? The time scale. Who decides who's going to be doing the work, providing the equipment, the materials? Have they got their own staff? Do they have their own clients? How do you know that they've got their own clients? Do you need to look behind what they've said? And also, do they negotiate different fees for each job? And what Uber tells us is that simply tinkering with the written agreements isn't enough. You're going to need to focus on the arrangement. And if we go to the next slide and think about that in a little bit more, it's not just about looking at where you can show an inconsistency between the agreement and what you do. If it's the type of relationship that the law needs to act, then the contract becomes less important. Now, if you're dealing with professional services where the service provider is not vulnerable, the position should be different. You should be able to start with the contract, but it's still got to reflect reality. Those key words, subordination, dependency, and control. Do you have a hierarchical relationship? So we think about whether you can simply redraft a contract so that someone's not considered to be a worker. The answer to that must be no. So what can you do? Well, you've got to ensure your written agreement reflects the arrangement, but you've got to decide what you want. You've got to decide, do you want to exercise a sufficient degree of control over those delivering your services so that it is a subordinate relationship? If you do, they will get employment protection. If you don't want them to have that protection, you can't have that control. So you've got to make the decision. You've got to decide what relationship you want, because it won't just come down to delivering that draft contract. Now, typically when I'm instructing these matters, I'm asked, what type of contract do we need to ensure that the service provider is considered self-employed, that they're not brought within IR35? So in terms of the order of things, we think, well, let's draft the contract, assess the status, and then adopt the arrangement. But thinking about this Uber case, it's got to be different. We've got to decide on the arrangement first. That's got to be the starting point. Then assess the status, and then draft a contract that reflects that arrangement. So that's everything from me on the Uber case. So I've just got time for a couple of questions. So Joe, if I ask you, you mentioned a lot about mutuality of obligations. Just explain to us briefly, how do you establish whether or not you've got that mutuality of obligation?
Yes, thanks, Ian. I have responded sort of privately to a couple of questions in between times as well. I hope that's been helpful. But yeah, I mean, it comes back to the fact that the bedrock of an employment relationship is that the employer is obliged to provide work and pay for that work, and the employee is obliged to do the work. That's the bedrock of the employment relationship. But in a self-employed relationship, there isn't that obligation. There isn't an obligation on the client, the customer, to provide work to that self-employed contractor, and then there isn't that obligation on the self-employed contractor to accept it. And one of the questions that I did answer privately was, what if you're anticipating a couple of, you know, one project coming to an end, but then another project starting? What matters is whether or not you are obliged to offer it to that particular worker, and that that particular worker is obliged to accept it. If there isn't that you know, obligation, if you like, then I think that defeats the concept of mutuality of obligation, which is the bedrock of an employment relationship, and makes the relationship more akin to a self-employed one. Does that help, Ian?
Yes, thanks, Joe. It certainly does. And you can see our email addresses there. So thank you very much for joining us. Do contact Joe or I. We will make the slides available, and we will make a recording of this webinar available on our website. So thank you very much.